Thank you for that. Good afternoon, sir. It's a pleasure to be here. A topic of perennial significance, and it's a privilege to speak on it. Without wasting too much time, we are already running behind schedule. What I would like to say is that in a pluralistic, liberal democratic society, independence of judiciary is part of what I call constitutional patriotism. And as I understand constitutional patriotism, let it be understood as a civic bond which unites. And in this concept, will not in any way exclude, as generally done, any right to exit, with which I have very serious reservation. But nevertheless, an important part of constitutional patriotism. And why I say constitutional patriotism, because the existing system which we have, we subscribe to what is called constitutional supremacy. And because in constitutional supremacy, the concept of constitutional supremacy makes courts preeminent. And when I deal with courts and the preeminence of courts, I'm not entering into the controversy between an activist court and a conservative court, because that is, we take into the realm of counter-majoritarian dilemma, with which I'm not in this particular discourse concerned with. Because in either facet, whether as conservative or as activist, courts act as a check. That is a check outcomes for what is actually wanted or desired by those in authority. That is a check on that. It's not simply a preference, a choice. It gets a particular result. And the independence of judiciary in that extent, in that manner, acts as a check on that particular power. And this check on this particular power, why I say I will not make a distinction between an activist and a conservative judiciary, whether it is, say, a Golaknath or Gopalan, or whether it is Keshwan Bharti, whichever way you see. And so as courts are concerned, the courts have intervened to in some way impose some kind of disciplinary system, and the disciplinary system is absolutely critical for proper working of this particular system. And we have these courts and this concept in a milieu which is actually mandated in the Constitution, which enhances the power of the court. And it enhances the power of the court. That's the way our Constitution is actually formulated. And I deal not only with Part 3, which is actually limitation of the executive, and I deal not with 32 alone, I deal with 226, Article 26, which is expansive in its sweep, and it's expansive in its sweep because it goes beyond Part 3, that is authority itself, goes to persons, and therefore goes into the realm of private bodies also exercising public authority. So the sweep of the court is actually immense, and because the sweep of the court is actually immense, the question of the possibility of the court intervening actively, and the court should intervene actively in incidents and in cases where such intervention is warranted, is not only constitutionally sanctioned, but is warranted and is absolutely necessary. This is what we have to actually keep in mind when this aspect is concerned, more so because courts over a period of time have further enhanced the power, whether in diluting the question of locus, or of course applying conventional principles, etc., so as to increase access of the people to judiciary. And while they are dealing with the increase of access, I don't share the concern about public interest litigation. I think public interest litigation is a good thing, provided, of course, it's not abused, for which the checks are actually in place, because it is through that a participatory power of democracy can actually come. And it is in that way we will redeem the people from the streets and get them into the system to have the courts actually deal with this particular matter, which again will vindicate the issue of independence of the judiciary. Now, when we deal with independence of the judiciary, what are the certain non-negotiable things which are necessary for this which is absolutely mandatory and imperative for this independence judiciary to work? So I will just state them because that is absolutely necessary. One, adjudication must be open. Of course, there are restrictions to limitation, as in the Raj's case itself, but nevertheless, on the whole, adjudication should be open. Two, there should be certain minimal standards of fairness in adjudication. This is absolutely imperative too, because without standards of fairness, procedural fair play, the question of any substantive good will not in any way arise. Three, the most important, independence of the judge. Now, independence of the judge is critical because the system cannot work itself. The system has to work through a judge. And therefore, the independence of the judge is the most critical feature of it. And the independence alone will not, it has to be intelligent independence. Intelligent independence will therefore get in some kind of capacity, credibility, character. So independence alone is something which is a concept which is used a lot, a concept not understood fully. To understand independence, you have to deal with courage, you have to deal with capacity, and you have to deal with character. This is absolutely important. Number four, what is important is also institutional coherence, and this is extremely necessary because we have the judiciary as a coordinate arm of the government. So the judiciary should usually speak in one voice, and speak in one voice because there has to be some unanimity on the question of principle, because there is unanimity in the question of principle. In that way, what the judiciary says will therefore have greater meaning. Number 5, what is also important is that there has to be a fiduciary nature. That is power for a purpose. The beneficiary being the public. That is, in this power is not given to empower the person who has it. The power is given for doing of good. The doing of good is actually basically a quality. So therefore, this issue is basically the fiduciary nature of power where this question is concerned must not ever be forgotten. And most importantly, Justice Gogoi over here, the significance, the pivotal significance of the head of the institution. That is absolutely, because the pater familias, the one who actually controls it, the one who symbolizes it, the one who works it. And as far as this is the most important institution which has to be cherished, it has to be protected, and which has to work too. So it has to be a combination of how you approach it and how it is worked. So these things which in some way have necessarily to be kept in mind when we deal with the independence of judiciary. And it is to protect these that we have a system. We have constitutional provisions. We have constitutional provisions 124 to 17, which give protection. Now, why have I said this? I mentioned the non-negotiables first, because the protection is not an end in itself. The protection is for a purpose. The purpose is the manner in which systems to work, and the system to work, the non-negotiable that are necessary. So, in empirical analysis, the system must necessarily show and evaluate the approval. So you just don't see, okay, we have got these, we have got a system in place, we got these provisions also, we've got appointments which follow. That is the form in which it should work. The substance of it is the manner in which it will work. And in the manner in which it is working, the evaluative significance of it becomes important. So the empirical will go with the evaluative, where this particular aspect is concerned. Now, as far as the courts are concerned, I just mentioned that as far as the courts are concerned, they are a coordinate arm. They are a coordinate arm and therefore important. Now, because they are a coordinate arm, sometimes the power is immense too. Because the power is immense, it's an activist court. I'm not talking about a conservative court. Conservative court has got its own problems. A conservative court can actually lean toward what is called Retd. And as far as the rule of the judges is concerned, they cannot also be a system, and that is something to also affect. That is, you cannot go beyond a defined sphere of your activity, keeping the core nature of this particular function intact, and do the utmost within the confines of that particular system. But by working the system, not exceed your brief or the jurisdiction and expand the remit to become something completely distinct from what you actually meant to be. So much of the criticism that the courts have not done this, the courts have not done that, sometimes misses the point that as the restraints are there on the court and the manner in which the court must function. And in any case, sometimes the judges too may assume more than what is actually permitted. And while executivizing the judiciary is a problem, judicializing the executive is an equal problem. So we have to balance the two, that there cannot be a judiciary which is executive branch. At the same time, the judiciary cannot virtually take over the executive. And I'm concentrating on the executive because as in the existing system as it stands, the legislature, because the way in which it is functioning in today's scheme of things of inferior importance, because we got a dominant executive. The dominant executive and the court are basically the two is basically critical for the purpose of independence of judiciary. Why not this particular issue? I mentioned the requirement of coordinate organ. So what are the associated facets of a coordinate organ relevant to independence of the judiciary? And when we look at the coordinate aspects of it, what you have to see is the issue of separation of powers. Separation of powers cannot in any way be ignored as the question is. And while we deal more or less in a routine fashion of separation of powers, and we have a concept of independence judiciary. At times, what is important is independence judiciary as a value is not something which is all assuming, and it's not something which consumes the whole system. Along with the independence of judiciary is also certain other values that are equally important, which must necessarily be balanced, because judiciary is part of a system of governance, and because it's part of the system of governance, I'm not saying that you will integrate it in the manner first which it's losing its identity altogether. But by dealing with one value, you cannot give it that preeminence as to render redundant all other values of the system too. So there has to be a coordination, that is a holistic approach as far as to deal with the values in combination, which is extremely important where this is concerned. And when I talk about this, a part of independence, the need to maintain the other checks. Like we have the judiciary and the executive, but we have the executive and the legislature. And the judiciary has a role to play also in that. It is not only in the interrelationship between the executive and the judiciary the concept of independence will come. And so far as regulating the executive or the legislature too, that is maintaining the system. That is maintaining the system. But the bicameralism is concerned, for instance, so that the working system is concerned, the judiciary has an important role there, not only where an impact on the judiciary itself is concerned, but its oversight. The oversight of the system to deal with all aspects of it for the purpose of ascertaining that the system works. And because insofar as the judiciary is concerned, until the judiciary works, the system will not work. Because the only way the system can work is for the system to know its limits, and it is the judiciary which sets and defines those limits and actually enforces those particular limits. Now, coming back to the question of independence of judiciary, what we have to see is that because of the very nature of the judicial function, and your topic talks about contemporary challenges, I have a certain difference of opinion that's concerned. The challenges that are called contemporary are actually perennial challenges. It's not something has come up all of a sudden. Something new is happening over here. There's something which is unprecedented is happening over here. Why contemporary challenge? We are talking about concepts, we are talking about ideas. So they are challenges. And the challenges have remained common across. We've faced those challenges, we've confronted the challenges, we've overcome those challenges. And we've got a robust judiciary. Yes, it has had its lows, but has had its highs also. On a balance, when you look at the system, you look at the system on a balance. And on a balance, and that's not credit only to the judiciary, that credit is also to, of course, our society and our allied society, and the work of effective communication, that is, which has been lost in the abuse which has preceded this particular webinar, and to which I will address later, because then you have to critique something. You critique something on the basis of concepts and principles. You don't critique something on the basis of opinions or ideologies, and you don't in any way mask whatever you are saying. That is, mask your personal opinion as a principal criticism, which is feeling of our system in any case, but we'll deal with that later. Now, what are the problems which have been there? So far as this question, look at the question of supersession. The problem of supersession, there was almost a supersession in the very first year itself. At 9, no, does anyone talk about it? No, there was supersession also in the 70s. And whenever, and it's happened, the rumor mills always keep going to overdrive whenever a new chief justice comes. Generally, in the part of chief justice, will not happen. Why does this issue happen? Because the possibility of a collision, the possibility of some kind of disharmony between the executive and the judiciary. Disharmony in the sense, I won't call it disharmony. Disharmony itself can be part of the system, because you cannot possibly work a system by aligning the thinking. You have to work the system for the purposes of working your respective portion of the system and doing a good job about it. But the question is, executives also have been in some way having animals against the judiciary, and this one facet of it was insofar as the question of supersession happened almost the time of would happen. Mrs. Gandhi, we hear rumors about it also, fortunately hasn't happened and will not happen, and that's because independence of judiciary as a value is now recognized. Number two, encomiums. We will talk about issues having encomiums of the executive. In encomiums of the executive, yes, an aberrant encomium. It should not be something which has been made much fuss about. But have encomiums come only right now? No, encomiums have been always part. They had an exemplary form in the 80s when Mrs. Gandhi won the election and Justice Lagwati wrote the letter about it. Or they have been part of judgments too, when judges are back eloquent about how effective the system was during the emergency, when habeas corpus petition used to come to Supreme Court. So that's something new, but a problem nevertheless. These problems too have been there. Problems again which show that there are issues. These are not contemporary challenges. These are perennial challenges. But challenges because of the institution which is there and existing. Number three, the tug of war. The tug of war. You have a judgment here, you've got a legislation to override it. Or you have an ordinance come. Now, technically, this is also part of the system itself. A legislature is supposed to enact laws. The ordinances is a power conferred to the executive. It's a legislative power itself. Now, the question is, why is the power exercised? The motive behind it. The motive behind it, of course, when you're dealing with legislation, the motive is not relevant as long as competence is there. But while the competence is there, sometimes the acts which are passed or the ordinances which are being made fall foul of some kind of constitutional prohibition. But nevertheless, while they have the mask of legality in it, The reason behind that is this problem, the tension between the executive and the legislature. This is also nothing which has happened now, not a contemporary challenge, sir. The challenge is actually there, has always been there. Number 4, the intertwining. The intertwining of the executive and the the judiciary or the legislature. The intertwining sometimes it is stretched to apply to things which do not actually exist. In a few situations, it may give the semblance of so. And I'm dealing with the question of semblance of so. And because when you're dealing with the justice delivery system, semblance is very important, because as is the principle which we all follow where bias is concerned, it is not the existence of bias, it's the appearance of bias. That is, so far as the conduct is concerned, this is something which happens at times that unwittingly, unknowingly, for reasons having nothing to do with the person itself, an appearance comes up of something that is wrong, and there comes the question of majority as to the criticism. That you may criticize, we criticize it on question of principle. But now what happens in these cases? Criticism extends, and criticism extends to the past. And then criticism has uncanny linkages, like you sometimes link the criticism to judgments. You say, okay, see, that judgment was passed, and therefore this happened because of it. Now, these leaps of imagination which normally happen over there can be avoided. Criticize, yes, because this is necessary, which is necessary to criticize. You have an opinion. The diversity in opinion is absolutely warranted and necessary. But don't stretch it. But much as you maintain limits, confine on present principle, and actually deal with this. And finally, the most important, the pivotal position of a Chief Justice. Because the Chief Justice is the most important person in this entire system. And because the Chief Justice is the most important, the representative of the judiciary, the epitome of what the value of the judiciary actually represents. And therefore, it is in the Chief Justice alone that we will actually find all the merits and all the demerits of the system, because how the system works will be in some way related to the Chief Justice, who is the face of that particular system. And because it's the face of the system, and as this particular issue has to be examined, he will also be criticized. And we should be criticized. No Chief Justice will want to be immune from criticism. But as far as the criticism is concerned, criticize rationally, and as far as the subject of criticism is concerned, respond in a similar manner. As is happening over here, we have this particular webinar over here, preceded by controversy. The rumor mill is saying that they'll be walking, the panelists will walk out of this. It was not walked out. They are here. We deal with the question in any case, but without getting into this particular issue, the importance of the Chief Justice and the role the Chief Justice plays is therefore very important. Now, after having said all this, what is it? I mean, how is it that we deal with this? How is it that we deal with the system? Can we have a system which is perfect, a law which is not open to interpretation, a method in which there is no discretion, a system in which there is no choice? You cannot. You have various problems, various issues come, different kind of problems are actually raised, whether it is for the party is concerned, or the transfer is concerned, or allocation of work is concerned, all these things. Now, in all these things, we have different people coming up with different statements. Okay, I think this system will be better. Or let's adopt a system which is somewhere in another country, UK. Let's get the system of UK over here, as far as concerned. Apply the system also, that will be. Now, the problem with this is that no matter how precise the law, no matter how comprehensive the reach, as long as with any system, there's a possibility of discretion. There's an element of choice. There are alternatives which are there over there. It will create a problem. And it is bound to create a problem because the choice may not be shared. And because the choice cannot be shared, the question of a choice being exercised in one particular way will cause a controversy, because the critique will be dissatisfied not with the bucket system. The existence of the choice is implicit in the system, but because of the way the choice is exercised, and that is where the problem therefore is not in the working system. The problem is a disagreement with the choice which has been exercised. So the choice is factored into the system, but then not to be dealing with it. We can't possibly say that every choice is right, and we can't also say that because the choice is exercised, the choice cannot be criticized. So while the choice is there, the choice can be criticized too. So how do we deal with it? And we deal with it here, and this is very important. We deal with the importance of constitutionalism. This is the most important thing. This is so far as the values, the culture, the attitude, which have in some way to be embedded in us. in our thought process, in our thinking, so that to act as a guide for making the choices, the person who's supposed to make the choice, and for criticizing the choices for those who are the critics. Because the problem here is ideology substitutes principle, which I'll deal with later. Choices may be wrong, but why are the choices wrong? In the sense that they merit disapproval of a person who is confronted with the choice, or are they wrong in principle? So this is a difference that must necessarily be taken. And how do we keep that difference in mind? One, we must necessarily have proper conventions, and that is where as far as convention is concerned, convention will not be just precedent. A convention cannot be something that happened in the past. A convention has to be healthy precedent. That is, when a convention is done, there is a belief in the utility of that particular convention and the justification for it. There can be only one instance for it, but there may be multiple instances of it. We need to have healthy convention. The healthy convention will show an intellectual spiritual maturity. And no system of independence can work without that particular maturity being over there. The issue of maturity has to be there in any case. Number two, we have to develop ethics. You can't have convention, you can't talk about right or wrong without having ethics. And ethics in any case, again, ethics in the sense, ethics is understood as the understanding of what is right, as far as the development of ethics, not as constitutional ethics. Ethics in the sense are social ethics also will be very important. What we consider acceptable, what we think is a norm which should be followed, how we see ourselves as a society, what is the value we think is preeminent, in what way do you think that we should move, how is it that we'll be happy about ourselves. That is something as far as ethics is concerned. And number three, we have necessarily to have respect for the system. Because unless you have respect for the system, and unless you actually feel that the system has to be sustained, and while the system may be critiqued, but it cannot be either critique, be undone. You cannot undermine the system whatsoever. It's a very thin line which is over there. I'm not saying, I'm not averse. I mean, I personally, I think criticism should be open. Criticism should be uncompromising, because unless criticism is this, the criticism doesn't in any way fit the bill of a criticism. Because criticism, there should be no holding back. And as a country, I feel we have lost being that capacity of being robust enough to confront criticism, and we have to build that, because we can't talk about independence judiciary alone without inculcating the values which make that independence worthwhile. So these are the things as far as constitutional is concerned, conventions, ethics is very important for the purpose of independence of judiciary in any case. Now, what are the problems? What are the problems which arise over here? And the problems, I'll just list some problems which come over here. And I dealt with one briefly when I was in the middle of what I was saying. The one issue is, as far as question is concerned, the replacement of ideology of principle. And what I personally feel, and what I know, any study of our legal system will show that the people criticizing change, but what is criticized remains constant. Now this is slightly uncanny, and why does that happen? Because it depends on the ideology the time is. Now, as long as the dominant ideology of the time sets the norm, as far as the critics are concerned, the critics are those who are in some way aberrant where the ideology is concerned. And because for a phase, they feel that they are in some way disempowered, because the system with which they work is not as accessible to them. So, an ideological viewpoint then comes in as a criticism of this. Now, the criticism, there may be a criticism, yes, but then what is motivating the criticism? So, at times, which is something as students, what you have to see is the criticism one on principle? Because unless criticism is one on principle, you cannot possibly have ideology to justify it. And ideology, I deal with both right and left. I mean, I'm not in any way taking sides. Ideology, I think this applies across the spectrum. It applies across the time. So that is not the issue here. The question is, as mature, sensible people, concerned about the country, committed to its independence, and interested in its welfare, we have to be in some way objective and rational about our criticism. Be absolutely forthcoming about what we feel, but not hold back about what we think. But now let's criticize the question of principle only. Number two, what I feel is that many times the criticism is without a context. That normally happens, that when you criticize, you miss the context. And I'll give you some examples, like of course very controversial examples too. These are Now, insofar as the question of transparency in appointment is concerned, that's my personal view in any case. Now, transparency in appointment of transfer, you say, okay, reasons. Now, I'm not, insofar as this is concerned, when you're dealing with an appointment, for example, you are dealing with judicial careers of lawyers too, who will be coming. And if you give detailed reasons as to why they are appointed or not appointed in any case, with a fair amount of period left for them yet to practice, they'll be forever maligned and condemned because of some kind of negative comment which may come, maybe justified or not, about them. So the question of, so when we talk about criticism, we have to have a contextualized understanding of it. In that context, what is the extent of transparency that you want? Don't just go about transparency in any case. At any transparency is the value itself. As I said, values compete. And what value should be predominant depends upon the situation in that case. Number two, secrecy. Much has been said about, say, the things being handed across the court. I am very against things being handed across in court. I personally feel that yes, as far as this issue is concerned, adjudication must be open. But again, just like adjudication be open has got the exception, depends upon what is the stage. What is the stage of that particular adjudication? Now, suppose it's stage of investigation. And in investigation, in any case, there is no involvement of an accused in the investigation, except, of course, where the person is concerned dealing with infringement of rights as such. And investigation may at some kind of time reveal things which may not be shared because the investigation is still not over. To then insist upon the value of openness, so as to in some way impact upon integrity. When the matter is before a judge, and the question of trust in the judge is also important. Of course, there will be people who will be mocking me for saying, you see, you trust the judges. We have to trust the judges too. We cannot possibly say they are entrusted matters of life and death. We are subject to criticism. They will make mistakes. We are entitled to say that they are wrong. But neither that doesn't necessarily mean that trust must necessarily go down. There has to be an element of trust along with the criticism which has to be there. Since the question of secrecy is concerned, that also has to be, because we have to be nuanced criticism of this. In the question of roster, not, I mean, I don't feel, as far as this question is concerned, a petition goes to the court of collegial system. Now, I have doubts about the very legality of a collegial system in the constitution as it stands. To have a collegial system in so far as the roster is concerned, that is again talking about a system, because as far as the issue is concerned, the problem may not necessarily be with the system as such, the manner in which the person is working the system. And a collegial system is impracticable. And I personally feel you cannot possibly have a collegial system in that. Collegial system in itself is, in my opinion, is of dubious legality. I mean, on first principle, I have a very serious reservation for the collegial system. To extend such a principle to a roster system, in my opinion, is again not into it, but that's my opinion. But the point is, we have to talk of it in context. Number four, we talk about Ayodhya. Now we talk about Ayodhya, yes. Now we say, now see, who wrote Ayodhya? And you say, how can you have judgments like these? How can you have judgments? But what is per curiam? You have per curiam judgments. Per curiam judgments are not something unknown. Per curiam judgments have existed over time. Per curiam judgments are no longer for those non-controversial orders too. Sometimes per curiam judgments are for controversial issues too. And if the institution talks as a body, so as to assume responsibility for the decision, and while talking as a body and assuming responsibility for its decision, comes across with a verdict, that the verdict is specific, where the judges disagree, where on an issue they disagree. And the verdict has got reasons, they might disagree with the reasons. You can't possibly make a furor of the fact that who's the author of the judgment. The question is, the court has spoken, and on a controversy as big as this, if there's a device, a strategy which is in some way evolved for the purposes of the institution to speak for itself, what is wrong with that? And that is again my personal opinion. So what I'm saying is, you cannot just run down an institution by saying, okay, who's the author? Because you have to deal with exceptions to per curiam. How per curiam is unwarranted over here? Also deal with those things and you can address them and then deal with it also. So those are the questions which will in any way which we have necessarily to address. Next is the issue of language. I personally think that communicative competence is very important. Because if it degenerates into abuse, then the whole purpose of criticism goes. Because a criticism is supposed to be constructive. And a criticism which is abusive is only destructive. And destructive criticism has got no worth. And as a country, we have to, as I always say, have to stand up, take it on the chin, face what we think we disagree with, meet it, confront it reasonably, rationally. That's what a pluralistic society is. And that's what constitutionalism mandates. And that is what judicial independence is actually premised upon. So these are apart from this, there are certain other issues also which come, but most important, credibility. And credibility is extremely important. And for credibility, both the people holding the office and those criticizing, both should have credibility, because credibility addresses all concerns. And when credibility addresses all concerns, so as many of the rumor mongering which comes, the many of the suggestions, the sort of voices which come, the many of the ways in which certain indiscriminate methods are actually evolved for the purposes of criticizing will in some way be affected, and credibility, as I pointed out, brings in question the constitution, norms, in any case, personal integrity of the person concerned. So the endeavor has to be to build credibility. And credibility is not something which has to be announced. Credibility is something which is recognized. And because credibility will be recognized, credibility is the answer to any criticism. And if the credibility is the answer to any criticism, the system is robust enough to face any kind of criticism. And that's the reason why I will go furtherly was appointed to the governor. Of course, Chitlalwad criticized it. No one in any case by was banned. The gentleman was an extraordinary judge, a man of extreme credibility. Why did we not? We have Golak Nath in one case, but we have ADM double in the other case. We talk about ADM double, we don't talk about Gopalan. Why do we not talk about Gopalan and talk only about ADM double? And so, the strict understanding is a strict understanding. Again, credibility comes in. So, the question of credibility is also important where this is concerned. And finally, because I want Justice Gogoi also to deal with it, not take too much time. Even as far as this question of, because it's a question of in-house procedure, etc. I must deal with this in-house procedure. They say, see, in-house procedure bad. I don't think in-house procedure is bad. I stick my neck out to say that in-house procedure is not bad, because I personally feel that the method is devised for the court in the kind of country we are, the way in which this works, to have complaints coming for judges and to have external agencies deal with it will in many ways undermine the system and damage it. I do not think that in so far this question is concerned, making a statutory basis, you have a statutory basis system in the UK. And you have a statutory UK, minuscule, considering the total number of judges that are there in the UK, in the complaint mechanism, only a minuscule, a fraction of complaints are actually taken into account. Why? Now, we always look at the rest. We look at the US, we look at the UK. We don't have confidence in ourselves. We don't have confidence in our jurisprudence. We want reassurance. We want to see what the British do. We want to see what the Americans do. We want to see what the South Africans do. We want to see what the Australians do. We really don't worry about what we do, and we don't want to build our own jurisprudence. Rather than borrowing from anyone else, we have to actually build a jurisprudence for our own. And to build a jurisprudence will not only be an academic exercise. This building a jurisprudence requires character. And when I talk about independence of the judiciary has got everything to do with character. And it eventually comes down to this, that as this issue is concerned, character and credibility alone will sustain independence judiciary. Problems will be aplenty, but there are no problems which cannot be faced, there are no problems which cannot be solved. And it will be appropriate that as the creed, as Justice Krishna had said, the creed of judicial independence is the constitutional religion. We need to treat it with sanctity, treat it with respect. It's for that reason that we call our courts temples too. And we keep that in mind when we talk about it, because this process is sacred. And this process is important, and the process should not be defiled by needlessly straying into a domain which is irrelevant or bringing into factors which are completely extraneous or unnecessary. That's all.
Thank you so much, sir. Those were that was a very expansive and elaborate description upon the subject. I'd like to invite, without further ado, Justice Gogoi for speaking on the same topic.
Very good afternoon to everybody. I wonder how much time I have. The package, your webinar package is important. We had a great start. It was wonderful listening to Mr. Lekhi. He was, as usual, brilliant as in court. I had listened to him again and again and again for 5 years. He was as good today. I will take about 15 minutes. I'll come down to ground rules. And then I would naturally like to leave some time for some questions. This is my personal opinion, and it is a little negative. There are debates, discussions, seminars of late have lost their intellectual character. At the slightest opportunity, they become events of vilification of the idea, if not of the person entertaining the idea. At the very outset, when the introduction was made, Mr. Siddharth talked about the reaction in social media to this webinar and my participation. These are the people who believe in the concept of the independence of the judiciary, but they would not permit an individual, a former Chief Justice, to have independent thought and express it. The more I heard about these expressions of opinion, the more determined I became to take part in this webinar. And that's how I am here. Independence of the judiciary. Contemporary challenges is the broad area on which I am required to address you. Independence of the judiciary, I would put in two categories: independence of the institution and the independence of the individual judge. So far as independence of the institution is concerned, I start with the appointment system, the collegium system. I have been a part and parcel of the collegium for 3 years, from 19th of November 2016 to 17th of November 2019. For 3 years, I have been a member of the collegium. The collegium is a judicial evolution. If you have problems with that evolution, the resolution has to be within the law. My experience with the collegium system has been that it is a sure way of keeping executive interference out of the appointment process. Not that the executive does not have a role. The executive has a role. The executive is a partner in the decision-making process leading to appointments. But the executive is not an equal partner. The judicial voice is the ultimate voice. In my tenure as the Chief Justice of India, the collegium recommended 14 names for appointment to the Supreme Court. 14, 1-4. Nearly half of the Supreme Court. These recommendations were accepted and the appointment orders came in time. Never for a moment there was any difficulty. The collegium headed by me recommended about 24, 25 Chief Justices of the High Courts. All the recommendations came through in record time. Any problem with the names? Fine judges. No executive interference. Never for a moment. What is the problem? You see, a perception that Judge A is better suited to be elevated to the Supreme Court than Judge B is an individual perception that a person may entertain. But the final decision has to be between person A and person B and to be taken by the collegium. Between A and B, if both are good judges, and the collegium opts for B, and somebody feels that no, it should have opted for A, that doesn't make the system bad. That doesn't make the appointment bad. Now, Mr. Lekhi has mentioned transparency. No, it's like the choosing between the devil and the deep sea. How much of transparency? Ground realities. Mr. Lekhi has mentioned, and it's a fact. You don't find a person suitable, either an advocate or a subordinate district judge. You don't find him suitable for appointment. You have your reasons. You put these reasons in the public domain, the man suffers. His family suffers. If you don't put it in the public domain, it is not a transparent process. What the collegium, so far as I'm concerned, did was to briefly record the reasons and put it in the public domain, giving an indication of the sources of the information which has led to the conclusion as to why the person is not suitable. Presently, I find that the collegium resolutions are even more brief. I have nothing to say about that. Transfers. Each transfer has a reason which may not be very complementary to the transferee judge. If these reasons which are not complementary are to be brought on the public domain, it will not only affect the future of the judge, the future functioning of that particular judge, it may also cast a doubt and give room for speculation to the judgments that he has delivered. If for some good reasons a particular judge is to be transferred from High Court A to High Court B, if the reasons are in the public domain, I, for one, can foresee a long line of review petitions seeking review of the judgments passed by that particular judge. What do? Therefore, we have a system which has worked, which is working fine. The problem is not with the system. The problem may be, if there is one, with the individuals who are running the system. And here, the problem necessarily need not be amongst the collegium members. The problems could come from outside the collegium, but within the judicial fraternity. Beyond that, I don't think I should say anything. So, the problem lies with the individuals. Why do you blame the system? The NJSC was an exercise that was stillborn. I don't wish to comment on the merits of the judgment, but the judgment to my mind is a very simple, short one, though thousands of pages have been written. The composition of the issue boiled down to the two independent persons who is to select them. The collegium that was to select the two individual persons to form the commission is the Prime Minister, the Chief Justice of India, and the leader of the opposition. The court took the view that since out of 6, there are only 3 judges, and the other 3 judges are the other 3 members. One is the law minister, and the other 2 are the eminent persons to be chosen by this collegium. It is not a fair system. It has its impact on the independence of the judiciary. The judicial voice, the predominant judicial voice, is sought to be curtailed. This is the basis of the judgment. So we are back to the collegium system. In my mind, it's an excellent system. It has worked well. It has stood the test of time, and perhaps some amount of self-restraint, some amount of discipline, some amount of greater responsibility of all who are associated with the collegium system can even make it work. There will always be a section of people who will not be satisfied. The idea is not to satisfy anybody. The idea is to be true to the work that the law and the constitution has assigned. So this is an institutional protection so far as independence of the judiciary as an institution is concerned. Now, Mr. Lekhi mentioned something about an in-house procedure. You know, I don't think I should be hesitating in telling you that every week the number of complaints regarding judges and their conduct in different areas, in adjudication process, outside court, acquisition of property, this, that. The number of complaints that come before the Chief Justice of India every week would be around 300. 300 complaints. Each of these complaints have to be attended to, numbered, and entered in the register. And the Chief Justice is required to take a call as to what should be done. Now, so far as the complaints or allegations against the judge is concerned, that can be inquired into in two ways. One is, I would say, the parliamentary route, where 100 members of the Lok Sabha or 50 members of the Rajya Sabha moves an impeachment motion. That impeachment motion, if admitted, is preceded by an inquiry under the Judges Inquiry Act. But when there are 300 complaints against judges every week, you can't have the parliament getting into all that unless the matter is very, very serious. The Chief Justice takes a call. Now, if the Chief Justice finds, I'm talking about the Chief Justice of India, because if the complaint is to the Chief Justice of a High Court, it is sent to the Chief Justice of India. Now, if the Chief Justice of India takes a call that the complaint is serious enough, the first thing he can do under the in-house procedure is to call for comments of the judge concerned. Now, the in-house procedure, evolved in 1999, is available on the Supreme Court website. Please read it. I don't think many people have read it. It contemplates a three-stage process. If the complaint expressly does not disclose any room to go ahead, the Chief Justice of India dismisses it at the threshold, which he does in all, perhaps in all the 300 cases. If the complaint discloses something, the Chief Justice calls for a report or the comments of the judge concerned. On receipt of the comments of the judge, it can be dropped at that stage. It's only if the comments do not satisfy, we will go for an inquiry. This is the in-house inquiry. The procedure of in-house inquiry is common to a High Court judge, to a Supreme Court Chief Justice of a High Court, to a Supreme Court judge, and the Chief Justice of India. It's one procedure. It does not contemplate participation of lawyers, witnesses, cross-examination, no. It does not contemplate participation of outsiders. It is an in-house inquiry. What happens at the end of the inquiry? If the complaint is to be dismissed, the report is not to be made public. There is a good reason. It may embarrass the judge. The frivolous complaint may embarrass the judge. If the complaint is found to be of substance, the judge is asked to step down. If he doesn't step down, he is asked to abstain or ordered to abstain from doing judicial work, and the matter is referred to the President and the Prime Minister for taking the impeachment route. So it's not that the in-house inquiry is ineffective. If a judge is indicted in the in-house inquiry, he either has to quit on his own, failing which the matter will take the impeachment route, because the report of the inquiry goes to the President and the Prime Minister. And then the Judges' Inquiry Act comes in, and there will be a full-fledged inquiry of witnesses, lawyers, etc., etc. This is the constitutional scheme of protection of judges. In today's context, I think this scheme needs to be strengthened. As the Chief Justice of India for 13 months, I found good people not wanting to become judges. I found young members of the bar not keen to become judges. Why? The office of the judge of a higher court, the higher judiciary, has been made so vulnerable that a lawyer would be happy to continue as a lawyer. Don't forget the sacrifice that a lawyer makes when he becomes a judge. And from the smallest to the most lucrative high court, there is some sacrifice. It may vary in degree. Why would a lawyer give up a lucrative profession to come into a thankless job and face the vagaries of the situation where there is no protection? All you need to defame a judge today or to bring allegations against him is a complaint supported by an affidavit. Perhaps you need a lawyer, and perhaps you need a web portal. The judge is finished. The allegations may be unfounded, or found to be unfounded, but the damage is done. Which reasonable lawyer earning a good amount of fees would jump into this situation and want to become a judge? Therefore, in my mind, the in-house procedure has taken adequate care of safeguarding the constitutional protection afforded to the judges. At the same time, it provides for avenues for complainants to come and address the system. Again, I would say it needs to be strengthened. For the last 20 years, this in-house procedure has been in vogue. The details of that procedure have been uploaded on the Supreme Court website of late, a couple of years back. And I think, in my considered view, we need to strengthen this. You don't drive a judge to an inquiry straight away, where witnesses come and say all kinds of things. You won't be able to function. And if you do that, I see that a sufficient disincentive for any right-thinking lawyer to want to become a judge. God help the system. These are basically, apart from that, we have, it's too elementary to say that the salary of the judges, you can't attack. It enjoys a constitutional protection. It's charged on the consolidated fund. Whether the parliament passes a budget or not, the salary of the judges is assured. The judges won't stop. You can't stop the judges. Now, this is the institutional protection to ensure the independence of the judiciary as an institution. Now we come to the independence of the individual judge. See, traditionally, the necessity of insulation of a judge was felt to be from predatory attacks of the executive. The executive, in this way or the other, trying to influence the judge in the adjudicatory process. This is a danger. Speaking for myself, I can say I did not experience it. But it is a possibility. But added to this, it is my view that there is an equally dangerous, if not more, source that attacks or can attack the independence of the judiciary. Today, what we have in our country is an ideological group of people, call them activists, call them believers, call them leftists, call them whatever we may. The number of this group of people is far too less than the public space that they occupy. They're very loud. Then you have the social media. You have particular web portals. You have examples of mainstream media, both electronic and print. And on top of that, you have intellectuals. This is one group who have laid down identification marks for an independent judge. Who is an independent judge has been identified. And how it has been identified, what are these qualities? I find that these qualities are: a judge must be necessarily anti-establishment. He must be anti-authoritarianism, authoritarian. He must be eloquent on issues like rich-poor divide, oppression of the marginalized, issues pertaining to suppression of fundamental rights, and he must advocate free speech, even to the extent of touching the frontiers of defamation. These are the identification marks of an independent judge. And unless he satisfies them, he is not true to his oath. This is the danger. There is a group of people who expect judges to exercise their constitutional duties in a particular manner. And if you don't conform, you become the target of attack. The danger again lies in the system not being able to meet this threat to the independence of the judiciary, which can spell disaster. It will affect, if it has not already affected, present judges, and it will be a disincentive for good people to come and join the bench. I think we need to seriously ponder over these issues. You know, my experience has been that whenever you are in the midst of a hearing of a case, and naturally in the first court of the country, all cases are sensitive. If opinions are expressed as to whether the bench is thinking correctly or not. Next stage is indication of expectations of what the bench should do. And number three, if the bench does it, it's an independent bench to the oath and the Constitution. If the bench doesn't do it, attack the judge. Not criticize the judge. Mr. Lekhi was mentioning. You don't criticize, you attack the judge. Goes down. This is destructive of the independence of the judiciary. I believe young people who are the future of the Indian judiciary. Give it a thought. Give it a thought. The system is not averse to criticism. There is room for improvement in everybody, including the Chief Justice of India. But for heaven's sake, be dignified in your attack. Let there be an honest intellectual and academic exercise so far as judges are concerned. Don't impute, not imputation of motives. It is destructive of very that you are trying to protect, or which this section of people profess to protect. I don't think I should be saying anything more. I thank the CAN Foundation for this wonderful opportunity. In spite of all the technical glitches and limitations of technology, I hope you have been able to hear me.
Thank you so much, sir. We have had a pretty inquisitive and informative session with you. There were a lot of questions that had flowed in during the duration, and I would request our member panelists from the team to put up those questions before you and before Mr. Lekhi, so that we can handle them as they come by. The audience can meanwhile put in the questions under the questions tab, and we'll take them one by one. Over to you, panelists. Sriram sir, you're on mute. Please unmute yourself. You're not audible. Please start from the beginning.
I hope I'm audible. No, I'm so sorry. Sir, thank you so much once again, Justice Gogoi and Aman Lekhi. We've had so many questions coming. So from among those, we've merged a few questions, more than one question into one, and we've selected a few questions as well. So without much ado, I'll go into those questions. So the first question is, do you think that post-retirement appointments or say nominations to the parliament, etc., would legitimately cause reflect a previous reflection on the tenure of the former judge?
I suppose I have to answer it. Who has to answer it?
This question is to Justice Gogoi.
Yes, yes. Not unexpected, the question, being the first question. Because of what had preceded, as I had mentioned, this in the social media on this webinar. My answer to this question will be a little longish. You know, I would put retiring judges in three categories. Am I audible? Am I audible?
Yes, sir. You're audible.
I would put retiring judges in three categories. Number one, retired activist judges who immediately or little after retirement say many things which they felt they could not have said in office, and many things pertaining to freedom of speech, failures of the Indian judicial system, failure of the Supreme Court of India. This is one category. It brings them into prominence. Second category of retiring judges are those who do professional independent work, commercial work, arbitrations, opinions. And number three are judges who have for post-retirement engagements. Now, you talk about post-retirement engagements as compromising the independence of the judiciary. What about the other two categories? Who are the activist judges working with? Who's giving the platform to them? Who's propagating and expounding the views? What kind of connection did these retiring judges have with these people while they were in office? While they were hearing their cases? Questions asked. Retiring judges getting friendly with lawyers doing commercial work in the court? No questions asked. Out of hundreds of judges who retire, how does the work flow to few judges and not to others? No questions asked. Now I come to the third category. You know, BD brought out a paper in 2016. How many of you have read that paper? Out of 100 retiring judges, 70 have accepted post-retirement engagements. Out of the 70, about 50 have accepted post-retirement engagements which are statutory in character, tribunals, etc. About 30 accepted assignments or engagements where the appointment is made purely by the government. These are not statutory tribunals. Do you say that these 30 out of 100 have compromised the independence of the judiciary? See, it's an individual perception. It's an individual perception. So long you are clear in your own mind, there is no problem. A judge, while sitting in court, is expected to be true to his conscience. And I can proudly say that the vast majority of judges that they demit office and go to the extent of accepting a post-retirement package which is compromises the judiciary. It may happen in an individual case, but by and large, those figures given by BD itself indicates that exceptions may be there, but by and large, I don't think that is the situation. Eventually, it is the discretion left to the wisdom of the person. If he is true to his conscience, acceptance of a post-retirement offer is okay. You can take a decision, oblige it. You can take an honest decision. These are all individual, depends on individual. Yes, please, next question.
Good afternoon, sir. I am Aditya Khandekar. My question is for Honorable Justice Gogoi. Though your Lordship addressed this partly in your speech, but I'll just reframe the question that I have received from the audience. In cases where there are allegations raised against certain judges, sitting judges of the Honorable High Court or Supreme Court, of any kind of misconduct or pertaining to moral turpitude, does your Lordship feel that the existing system or mechanism is sufficient to ensure credibility or transparency and in the trust of the public in judiciary?
I think I have answered that question.
Yes, Your Lordship.
I have said, look, what I said. The Constitution contemplates protection to judges of the higher judiciary. And I have given details how it is worked out. Impeachment, in-house procedure, spelled out procedure, laid down in black and white, holding the field for the last 20 years. And in-house procedure also can lead to impeachment. In fact, it has led to impeachment. There is one case where the in-house procedure on the man, on the judge, charges proved. Impeachment, Judges Inquiry Act, inquiry was held under the Judges Inquiry Act. In that inquiry, the judge was exonerated. In-house procedure indicted him, the larger inquiry exonerated him. So this is what is serious. If you have any problems giving constitutional protection to the judges, take it away. Take it away. Hey, I am in Parliament now. It's not good. I will adopt the parliamentary route to get rid of protection to the judges. Then see what happens. What kind of people you will have as judges? Who want to become a judge? Would you want to become a judge? When writing a letter puts you on the dock, and 5 witnesses will come and say, he did it, he did it, he did it. You will say, no, I don't want to become a judge. Sorry. Maybe you are already you don't want to become a judge. Therefore, I have said, it is not only adequate, it needs to be strengthened if you want an independent judiciary. Yes, next question.
So, the next question we've selected is, are there enough safeguards for the absolute prerogative of the Chief Justice insofar as his position as the master of the roster is concerned, especially in light of allegations of forum shopping, bench selection, etc. concerned?
What does the Constitution say? Article 124. Supreme Court will consist of a Chief Justice and other judges. Hey. So the Chief Justice is different from the other judges. The Chief Justice is the first among equals. Somebody has to do this work. There are, say, I was the Chief Justice of Punjab and Haryana High Court. About 1,000 cases are filed every day. In the Supreme Court, I don't know, 300. Now, if each judge is to say, I'll take this case, I'll take this case, what is the, you can imagine the anarchy. Somebody has to decide. So what is decided is a subject roster. You may not know, but let me tell you. It's again in the Supreme Court website. The problem in today's the young crowd is they don't make an endeavor to know the facts. What you have in the Supreme Court and all the high courts is a subject roster. Say criminal appeals, direct taxes, indirect taxes. Which are the judges who will be taking it? That is the subject roster. The Chief Justice signs it. PIL, which is the bone of contention. Public law remedy, PIL, goes to whom? Initially, the PIL used to go to only the first court, the Chief Justice's court. Now, obviously, the Chief Justice cannot deal with all the PILs because there are so many PILs filed. So he assigns it to Judge A, Judge B. That was a controversy. During my tenure as the Chief Justice, what I did is that PIL will go to the first 5 courts. My successor, Justice Bobde, has expanded it to the first 10 courts. So if there are 20 PILs filed today, it may go to 10 courts, first 10 courts. What the Chief Justice decides is which PIL will go to which court. This is routinely decided by the registrar, who brings it to the notice of the Chief Justice. Unfortunately, it has to be the Chief Justice. Why I say unfortunately? Because he bears the attack. The attack is on him. Somebody has to do it. Who will do it? I will take up this case. Can but all the judges say, oh, no, I will do this, I will do that. It will be anarchy. Somebody has to do it, streamline it. That's the master of the master. Nothing more. Yes.
Good afternoon, Aman Lekhi sir, and everybody present here. My name is Abhikal Pratap Singh. I graduated from National University, Lucknow in 2013. Currently, I am practicing as an advocate on record at the Supreme Court. I am also fortunate enough to be a part of CAN Foundation from its beginning and the capacity of executive member. Sir, I am going to request Honorable Justice Gogoi to answer the following question, which is from the audience. Sir, is want of transparency in appointments and transfers affecting the independence of judiciary, particularly in the backdrop of recent decisions of not making the minutes of collegium public? Sir, is my question clear?
Absolutely clear. I think I have answered that question. Yes. I have answered that question.
Sir, from the audience, this is.
Yes. I have answered the question, but I'll elaborate.
Yes.
It's a catch-22 situation. Heads you win, tails I lose. You lose, I lose in any case. I'll give you one example. That should answer the question. I was not the Chief Justice. I think I was the number 2 judge or number 3 judge. And we considered the case of a district judge. Reports were not good, the IB reports. These were the initial days when we took a decision to upload our reasons. We uploaded it. Due to adverse IB reports, he is not found suitable. You know what happened to him? He obviously didn't become a High Court judge. He was 59, he was 58 or 57, whatever it is. In the normal course, he would have continued as a district judge till 60. The High Court said when the Supreme Court said that your reports are your adverse, you can't get any extension beyond 58. So what everybody gets 60 years, he didn't get. He went for retirement at 58. His family life was in the his family deserted him. His children disowned him. You want collegium reasons to be uploaded? I will upload it. I told my colleagues, I'll upload it. Mr. Lekhi mentioned about transfers. There was a transfer of a Chief Justice from one High Court to another. If I were to upload those reasons, God knows what would have happened. I had indicated to Mr. Lekhi that perhaps we would have seen a spate of review petitions. The reasons which led to the transfer are: number 1, conduct and character. Number 2, dubious financial deals. Number 3, acquisition of property. You want me to upload those reasons? पूछिए अपने audience से. These reasons you want to be uploaded. So if you upload, this is the consequence. If you don't, they say, no, this is not transparent. You have done it whimsically. You have done it whimsically. What arbitrary action by the collegium? You don't meet the acid test that this group of people have done for a good judge, for a good system of collegium working. It's a very painful duty. It's a very painful duty. It affects your sleep. It affects your mental peace. You're skating on thin ice all the time. Not very comfortable. These are not seats of power. The seat of a judge, the seat doing administrative work, the seat of the chair of the Chief Justice is not a seat of power. It's not a seat of comfort. It's not a seat of indulgence. It's a seat of duty. Difficult, very difficult, very difficult. I gave you the Madras example. I have given you this transfer example. So, what do? You listen to people who say you are arbitrary, you are short-sighted, and you are whimsical, and you are exercising favoritism. You listen to all these abuses. Who would want to become a judge to hear all this? So, young people, think about it. We still have people with a great deal of sanity, wisdom, patience, and tolerance, and above all, goodwill in the system. Let them flourish. Let them do their work. Don't dishearten them. Support them. Yes. Any further questions for me? Yes. Anything more for me?
There's one last question that's left. Sriram sir, I think that's on your part, on your screen.
Yeah.
Yes. Sriram sir, you're muted. Yeah, audible.
Hello, I hope I'm audible now.
Yeah.
So there's a lot of controversy around the Ayodhya judgment that there's no author to it. Don't you feel that such a practice tests the confidence of public in judiciary in such high-profile cases in which political outcomes are involved?
Why does a judgment need to? Is it a judgment that had no author? The author? And subtraction, refinement done by one particular judge or the Chief Justice. If there is one author, then can be five authors. Do you know that during the tenure of a particular Chief Justice of the Supreme Court, I think this was 2015-16, I have a list of 32 cases decided by that bench where the author of the judgment is not disclosed. 32 cases of a bench headed by a Chief Justice who held office in 2015 or 16. 32 cases, no author. No questions were raised. And some of the cases were highly contested commercial litigations involving thousands of crores. No questions asked. You asked that question and I was there. Speaking for myself, I have been the author of 13 judgments, right, where the name is not shown. You didn't question it. Check up. These are all reported in the Supreme Court cases. Check up. How many judgments I have delivered? How many judgments the other person has delivered? Right. Meaning the bench where I was there, the other person was there, but the author is not disclosed. You don't question it. You question about the Ayodhya. And there you are wrong, jurisprudentially. Per curiam, order of the court. Per curiam is an expression, is where the author is anonymous. It's an anonymous judgment, not unanimous, anonymous. Ayodhya coincidentally was both unanimous and anonymous. Anonymous. Ayodhya was anonymous. The author is not disclosed. Per curiam. It's a concept that came in initially for uncontested cases, small orders. But today, if you check out the jurisprudence, per curiam concept is well embedded even for contested cases. First of all, it is jurisprudentially acceptable. Secondly, it is logically people have pulled in their resources to write a judgment and they don't want their names to be disclosed. They don't want to take credit for anybody. Is it for anything? Is it not a self-sacrifice? And by each 5 of them, there could have been 5 judgments running into 5,000 pages. These critics, this question, I'm sorry, this question is posed by critics who want 5 judges to write 5 judgments so that the Ayodhya judgment become a retirement. If I had said I will write a judgment, the next judge will say I will also write, the third will say I will also write. So they will now write, and on 18th of November, when I they said we have not completed the judgment. This is what they wanted. Nothing more.
Thank you, sir. Now I will ask a question to Aman Lekhi, sir. Aman Lekhi, sir.
Yes.
Question is, should there be any post-retirement scrutiny for judges demitting office before they are handed over with any responsibility like being a tribunal or manning certain commissions?
No, I mean, you trust the judge with judgment. On his retirement, have to subject him to audit. This does not make sense because the power which the judge wields, highly holds office is immense, immeasurable. The system doesn't. This question doesn't have an easy answer. I'll have to just elaborate it slightly. One, I personally feel the retirement age must increase because the judges retire too early. This is not the age for retirement. Number two, the experience you have has to be utilized, and the experience is utilized in these cases, such appointments. It's not as if any of these tribunals don't function properly. Yes, I have some reservations about the tribunal system as such, but that apart, in the existing system, we don't have a perfect system. In this existing system, the utilization of the judges for the holding of these particular posts is necessary. Ideally, the retirement age should go up so that the judges are dispensing pure judicial functions for a longer period of time. The problem, however, here is that certain studies which show that the appointments are generally made of such where the political establishment has got a particular period of time surviving for the purposes of the appointment having efficacy. Now, as I said in my what I was saying, credibility is very important, and if a good judge is appointed, one would actually the whole issue will actually dissolve down to the person who's appointed. Of course, the circumstances the appointment is being made will be relevant too. But the factor of appointment being made by itself would not in any way be, in the existing setup, liable to be criticized the want of post-service audit. Ideally, I would say that there should be a gap of time. Ideally, there should be a period in which it should happen. But that's an ideal system. In any case, you don't have a system has to work with its imperfection. And with this imperfection, the manner in which the services are utilized, if they serve a purpose, I think we can accept that. So I don't believe in not on retirement audit is completely unacceptable. I mean, that's insulting the judge, the service, the whole institution as such, for the purposes of appointing a non-constitutional post, which just doesn't make sense at all.
Thank you, sir.
Keeping in mind the paucity of time, now we shall be moving to the vote of thanks by Mr. Aditya Khandekar, member of the CAN Foundation.
Before the vote of thanks, may I say something?
Definitely, sir. Please,
Yes,
please.
sir.
Most welcome.
Just adding one line to what Mr. Lekhi has said, increasing the retirement age for judges. In fact, as the Justice of India has recommended to the government that immediately the age of the High Court judges should be raised to 65. This was, now I think it's about a year. No problems. 62 is no age to retire, particularly if you become a High Court judge at 50 or 55. And secondly, there will be a freezing on retirements, and if for 3 years there is no retirement, and in these 3 years, if we can slowly bring good people into the system, the present problem of shortage of judges may be resolved to an extent. This is what I had in mind, and I hope the government will take it up quickly. Yeah.
Honorable Justice Gogoi, respected Aman Lekhi sir, and members of the audience, it is my privilege to be giving the vote to the distinguished speakers today. I, on behalf of Chief Executive Officer and all members of the CAN Foundation, extend our deep gratitude and sincere thanks for addressing this webinar today. We are for forward to further webinars as well as Aman Lekhi in the near future, so that we can be further, we can hear from your lordships and get some knowledge. Thank you so much.
Thank you. Thank you.